Good morning. Welcome to the First District Court of Appeals. The only case on the docket to be argued this morning is Shad versus Alder. Mr. Alt, you represent the appellant. How much time would you like to reserve for rebuttal?
Could I reserve 3 minutes, Your Honor?
Okay, very well. I will keep your time. You may proceed when you're ready.
Thank you so much. May it please the court. In response to an unprecedented pandemic, the Ohio General Assembly passed HB 197 to provide for ease and consistency in withholding for employers and to address the financial needs of cities which could arise because of the emergency stay-at-home order. Defendants argue that this amounts to nothing more than a question of tax policy, and the one that should be left to the discretion of the legislature. Candidly, it does not. Indeed, the legislature had at its disposal a number of tax policies that it could have implemented to achieve these goals. It could have modified the withholding rules to permit consistency during the emergency, while allowing taxpayers the ability to obtain refunds in a similar fashion to what the legislature did in the 20-day rule. Or it could have allocated tax dollars to the city from the local government fund, and it could have raised state income tax dollars to do so, to alleviate any shortfalls to the cities. Both of those would have been policy solutions. What it could not do is to violate the due process clause.
I guess I'm losing you here. Like, how are those scenarios that you sketched out consistent with due process, but the legislature's decision here runs afoul of due process? What's the distinction?
The distinction, Your Honor, comes from an unbroken line of 72 years of Ohio Supreme Court precedent, beginning in the 1950 case of Engel versus the city of Toledo, in which the Ohio Supreme Court first recognized the authority of a municipality to levy and collect municipal income taxes under rule, and also established the due process standard for challenges to those taxes. The Engel court answered 2 questions. The first was whether a municipality had any authority whatsoever to tax the income of non-residents. The court answered that question by holding that such authority exists pursuant to the Home Rule Amendment and subject to such limitations that the legislature may impose under Article 18.
Well, right. So it's legislative. And so my question is, if the legislature had said, we really like Cincinnati, and we're going to give Cincinnati the ability to tax anyone in the state of Ohio for its municipal income taxes, like, what does that run afoul of due process under your view of the world?
That violates the concept of due process as the Ohio Supreme Court held in Engel and for 72 years since. That because the second question that the Engel court addressed was the due process limitation of taxing non-residents arising from the U.S. Constitution's 5th and 14th Amendments. There, the Engel court borrowed from the U.S. Supreme Court's decision in state of Wisconsin versus J.C. Penney Company to adopt a fiscal relationship test for municipal income tax, which requires, that the tax bear a fiscal relation to the protections, opportunities, and benefits given. The Ohio Supreme Court has reaffirmed this test repeatedly. In 1961, in the case of McConnell versus City of Columbus, the court upheld the city's income tax against an Ohio resident who was not a Columbus resident by applying Engel's fiscal relation test, reasoning that even though the employee worked for an arm of the state of Ohio and on state property, he still performed his work within the city of Columbus, and that was key. Subsequently, in Thompson versus the city of Cincinnati, the court once again reaffirmed that there are 2 instances in which the city may tax wages. Quote, a municipality may tax wages realized within that municipality by a non-resident, citing Engel, and may tax the wages of a resident realized from a source outside the municipality. Recently, a unanimous Ohio Supreme Court summarized its 72 years of consistent precedent in Hillenmeyer versus Cleveland Board of Review. In that case, the court found that beyond in personam taxing over residents, local authorities may tax non-residents only if theirs is the jurisdiction.
Well, what about the 10th District's decision? Because they seem to have addressed the exact same issues that you've presented in your assignments of error. So would you have us create a district split and reject that decision?
Well, Your Honor, with due respect to that decision, first of all, it's only entitled to persuasive precedent authority. But
No, I understand.
second of all, I would argue that the 10th district already created a circuit split with the 5th district, which in the Von Cannell versus City of New Philadelphia case fundamentally rejected a number of the arguments that was adopted by that court. In that case, the court, looking at the extraterritorial application of a municipal income tax to individuals who worked at a UPS plant but were performing work outside the city, found that in applying the fiscal relation test, we find that the City of New Philadelphia violated the due process clause to the extent that it imposed an income tax on the portion of applicants' salaries that was attributable to work done outside the City of New Philadelphia. And in finding that, they noted that the mere fact that the City of New Philadelphia provided services to appellant's employer, such as protection against fire and theft, is insufficient to justify a tax against the employee under the fiscal relation test for work performed by the employee outside of the city. Furthermore, I would say that the Von Cannell decision is consistent with this 72 years of unbroken precedent from Engel through Hillenmeyer and beyond, which the Ohio Supreme Court has done.
Okay, so I appreciate all that, but I just want to make sure I understand the answer to my question, and that is, you want us to reject the 10th district decision?
Your Honor, I would argue that I want you to apply the Ohio Supreme Court's decision in Engel.
Okay, well, right, but I mean, are you trying to distinguish the decision, or do you just want us to say it's not persuasive, it's inconsistent with Ohio law, therefore we don't follow it?
I would argue the latter. I think if you take a look, that decision relies upon distinctions within the Hillenmeyer decision, which are not found in the opinion itself, namely that Mr. Hillenmeyer was not a resident of the state of Ohio. If you take a look, the Engel decision, the McConnell decision, the Thompson decision, all of which applied the fiscal relation test, all of which rejected the theory of extraterritorial taxation by municipalities, all involved citizens of the state of Ohio. If in fact the 10th district is right, then Hillenmeyer sub silentio overturned numerous previous decisions of the Ohio Supreme Court. That is not a standard mode of interpretation. We don't generally believe that one Supreme Court decision sub silentio would overturn 70 years of prior precedent. And in order to apply the 10th district decision, you would have to adopt that reasoning. Indeed, I think an error of the 10th district's opinion is it failed to actually adequately address the Engel line of cases. It simply addressed Hillenmeyer very narrowly. That said, I mean, Hillenmeyer's language is very, very supportive to our case. The court clarified that local taxation of non-resident compensation for services must be based on the location of the taxpayer when the services is performed. This is consistent with the line of cases from Engel forward, but it also comports with the limits of municipal taxation inherent in home rule. The home rule provision of the Ohio Constitution grants Cincinnati broad but not unbounded authority. Specifically, the home rule provision states that municipalities shall have the authority to exercise all powers of local government and to adopt and enforce within their limits such police, sanitary, and other similar regulations. As is evidenced from the face of the home rule provision of the Constitution, geography is a key limitation on municipal power. The Ohio Supreme Court acknowledged this limitation in Prudential Company Operative Realty versus Youngstown, in which it held that while the home rule provisions of the Ohio Constitution found in Article 18 confer certain powers upon municipalities, the provisions of that article do not confer any extraterritorial authority. The direct authority given by that article is expressly limited to the exercise of powers within the municipality.
Well, I guess, I mean, how do we deal with a situation, and I don't know how closely this tracks the facts in this case, but if you have a business that's in, downtown Cincinnati, and it has the servers, it has the technology infrastructure, it has the billing system, all of that is being done physically in Cincinnati, and your employee, the company's employee, works exclusively with everyone in that office, comes into that office sometimes, but is away from the office other times, but interfacing directly with that office. I mean, isn't that enough of a connection to that office to justify taxing that individual from Cincinnati?
Yes, Your Honor. The answer is no, it does not. And in fact, if you take a look at Cincinnati's tax ordinance, it makes it clear. And indeed, if you take a look at how they've even applied their tax ordinance in this case, absent HB 197, there's no question that the city would not have the authority to tax that individual that you're talking about on days that they're working outside of the city. Indeed, the city concedes as much by granting my client a refund for days that he would be working, that he worked from home, that would have been pursuant to his pre-existing working relationship, rather than for the days that he was working home pursuant to the emergency. This is consistent with the Van Cannel decision, where these were UPS drivers who were working many times remotely, but doing so with trucks and with facilities and probably with iPads and other equipment that were provided by their employer, who was housed in the city of New Philadelphia. The fact that they were interfacing with the offices there was not sufficient, in fact, to provide for taxation in that jurisdiction. They had to actually be performing the work.
So what is the result that your client gets a refund from Cincinnati and then has to pay Blue Ash taxes?
Yes, I mean, first of all, he would be my client would be liable for Blue Ash taxes by virtue of residency. Again, under the two theories, and the Ohio Supreme Court has previously found, because of these joint taxing authorities, an individual may owe residential income tax in addition to non-residential commuter taxes on the same income. So that's perfectly permissible. But yes, my client would then owe taxes to Blue Ash. And this, by the way, is consistent with the theory of the fiscal relation. In fact, it is Blue Ash, on the days that he is performing the work in Blue Ash, who is providing the governmental services to him. If Mr. Schad were to have a heart attack in the middle of the day, Cincinnati would not be sending emergency services to go ahead and provide him assistance. It would be where he's performing the work. It would be Blue Ash. So there's a logical reason, in addition to.
But he'd probably get brought to a Cincinnati hospital.
I apologize. I don't know sort of the contours of where there would be one, but wherever it is he's performing the work, ultimately they're the ones who are going to be maintaining the roads. They're going to be the ones who are providing police and fire services. Cincinnati is not. And so because of that, they actually don't have a claim to his tax dollars. The fiscal relationship is severed by virtue of the fact that he's geographically not performing the work there.
So if we rule in your favor, this is going to be depriving municipalities of a lot of tax revenue, because work from home is just so common now.
Well, Your Honor, a couple of things. Number one, while I think that it's a change in kind in some sense, we've seen this for a long time. Part of why, in fact, the legislature has actually tried to streamline some of the tax provisions. It's extraordinarily common, as I mentioned, and gave the example with the UPS drivers, but HVAC repairmen, plumbers. There's nothing new under the sun. If you take a look at Cincinnati's tax form, they already provide for refunds on days in which individuals are not working in the city, as they're legally required to do. The question of whether or not it's going to ultimately deprive tax dollars to the municipalities, that actually is a question of tax policy, which I would argue is ultimately one for the legislature to figure out. There are things that the municipality may wish to do as more individuals begin to work outside of the municipality because of telework, because of changing conditions, because people's choices. but they cannot violate due process in doing so. And on that,
Mr. Alt, you're at your time, but I think Judge Winkler had a question, so I wanted him to have a chance to ask the question.
And Mr. Alt, my understanding is that the city of Blue Ash and Cincinnati have a reciprocal agreement. So this goes to Judge Bergeron's question concerning the limits on the General Assembly. And I understand your argument is that it's an expansion of taxing authority of the city of Cincinnati as opposed to a limitation. But if we were to view it as a question among the other municipalities surrounding Cincinnati, isn't that a limitation on Blue Ash collecting income tax from your client?
Well, first of all, it wouldn't. That would be contingent upon what the terms are of that particular agreement, but it doesn't have to be. Blue Ash, again, would have much broader authority because it has in personam jurisdiction over Mr. Schad because he is a resident thereof. So Blue Ash can tax Mr. Schad's revenue any place he earns it in the world. There's no question about that in particular. But whether or not this isn't a weighing test with regard to authority, while it might act as a limitation there, Article 18, Section 13 of the Ohio Constitution restricts the General Assembly's power to limiting the power of municipalities to levy taxes. There's no question, it's undisputed in this case, that Cincinnati would not have the authority to tax Mr. Schad's income for days that he was working from home in the absence of HB 197. It is therefore undisputed logically undisputed that constitutes an expansion of the power of the municipality to tax. They could not tax in the absence of 197. So the fact that it may be a limit on Blue Ash, it is clearly an expansion of the authority with regard to the city of Cincinnati, and that is impermissible.
Okay, thank you, sir.
Thank you.
Thank you, Mr. Alt. We'll let you have rebuttal, even though we took you over a little bit. Mr. Anderson. And you're muted, Mr. Anderson.
Thank you. I'm sorry about that. Good morning. My name is Dan Anderson on behalf of the appellee here. As Mr. Alt recounted, at the outset of the pandemic, the governor directed that pretty much everyone work from home to the extent they could, with certain specified exceptions. The Assembly adopted Section 29 to try to address the municipal tax implications of that order, recognizing that a fair number of workers who had formerly been working, as in this case, in the city of Cincinnati, would be pivoting to working from home, as in this case, the appellant working from his home in Blue Ash. Section 29 dealt with that by deeming the work that was done by those, for lack of a better term, displaced workers to have been done in their principal place of work at the outset of the pandemic.
Well, help me understand this, because I think this makes sense for people who regularly came into the office pre-pandemic. But I remember my experience when I was practicing, and I might come into the office 5 days one week, but the next week I might be traveling. And that was really at the whim of deposition scheduling, court scheduling, client meetings, stuff like that. So I never had a consistent in and out of the office framework. It was just dictated by whatever came up. So like, how are employees like that treated under this framework?
Well, under the existing provisions of the revised code, for actual tax liability purposes, someone would be liable for municipal income tax absent Section 29 on the days they were actually working with.
No, I understand that, but I'm saying, like, how does Section 29 change it, and how does it impact a person in my hypothetical scenario who doesn't have a set policy, but kind of fluctuates in and out of the office, how do you tax that person? How does Cincinnati tax that person?
I have to be honest with you. I don't know specifically how Cincinnati would have taxed a person like that. There is a set of, there's provisions in the revised code for determining what a person's principal place of work is. And the way section 29 operates is it says whatever your principal place of work was as of the date that the governor issued the emergency order 2 years ago, to the extent that you're displaced by the pandemic, if your employer says, don't come into work in the office, work from home, as happened for a lot of us, those days are deemed to have been worked from the pre-pandemic principal place of work.
Now, the section was amended, right? Now the city is providing refunds to people for working from home.
Correct. The
Okay.
well, it's complicated because it happened in two different ways, more or less at the same time. But in June of last year, Governor DeWine rescinded the emergency declaration, which under the original section 29's terms meant that it ceased having effect on, I believe it's July 18th of 2021. But at about the same time when the legislature passed the biennial budget bill last year, they for tax year 2021, starting in January of 2021, they converted section 29 into a withholding only bill. So
But you don't believe that the prior version was only pertaining to withholding?
The plain language of the prior version that controlled for 2020 says it is for purposes of chapter 718, which is the chapter in the revised code that governs municipal income taxes. It's not, by its terms, it is not limited to withholding.
But it does specifically refer to 718.011, which is the withholding section, right?
That's true, but it also the language is and for purposes of chapter 718. And chapter 718 governs not only withholding, but also the ultimate income tax liability.
So in your view, is the amendment irrelevant to our consideration, or is there something that we should glean one way or the other from it?
The only thing to glean one way or the other is that this appeal is about the 2020 tax year. We are now into the tax refund season, the tax return season for the tax year 2021 that's just completed. Mr. Shad, I assume, will apply for a tax refund for 2021, and it will be dealt with by the city without reference to section 29, because section 29 will, as a result of the amendment, section 29 was not effective to determine his tax liability. So we, for this tax year of 2021, we'll return to the pre-pandemic rules.
So how is this a limitation or restriction versus an expansion? I mean, it seems like it is expanding the city's ability to tax people that are working outside its borders.
Well, I think there's two answers to that. And the first one is, with all due respect to my opposing counsel, there is nothing in the Ohio Constitution that says that the General Assembly can only restrict municipal taxation. Section 13 of Article 18 simply says that laws may be passed to restrict municipal taxation. But it doesn't say anything about whether or not they may pass laws to expand powers of municipal taxation. And in fact, the general rule is that under Article 2, Section 1 of the Constitution, the General Assembly has the power to adopt any laws that are not specifically prohibited by the Constitution.
So you're agreeing this is an expansion, not a limitation, but you're just saying the General Assembly has the authority to do it.
No, my first answer is that even if it is viewed as an expansion, that the General Assembly has the authority to do it. The second answer is that if you look at the Athens decision from the Supreme Court in 2020, where it, for the first time, really defined what the General Assembly's power of limitation means, the Athens court noted that the General Assembly has dictated to cities in section 718.04 of the revised code what their municipal income tax ordinances must look like. And therefore, any requirement adopted by the General Assembly has to be viewed as a limitation, regardless of whether the statute requires cities to do something or whether it simply prohibits them from doing something. The Athens decision says all of that has to be viewed as a limitation. So I think either way, Section 29 passes muster under the Ohio Constitution. I don't believe it's the case.
So to answer my question I posed to Mr. Ault, your view would be if the General Assembly said Cincinnati can tax whoever they want in Ohio, that's totally fine. That would comport with constitutional norms.
Well,
or is that going too far?
I think if the General Assembly, I mean, I hesitate to speak out too far in hypotheticals. I know at some point the General Assembly, every law passed by the General Assembly has to pass muster under the rational basis test. And so if you're talking about authorizing the city of Cincinnati to tax the income of someone who is in, Put in Bay or someplace up on Lake Erie, who has no connection whatsoever with the city of Cincinnati, I would certainly think that would pose significant questions in terms of whether there's a rational basis for that kind of legislation. That's a far cry from what we're talking about here, though.
Mr. Anderson, let me follow up on that question. And this mainly concerns the fiscal connection that Mr. Shad has with the city of Cincinnati. I certainly understand your arguments. He's using the servers, computers, et cetera. The business is located in Cincinnati. But what about a situation where there's somebody located out in a township or an unincorporated area, say up near Cleveland, and they work for the same employer as Mr. Shad does? What is the fiscal connection between somebody near Cleveland in an unincorporated area to the city of Cincinnati?
So in your hypothetical, it would be instead of living in Blue Ash, let's assume that Mr. Shad lived, as you say, up in an unincorporated area up near Cleveland.
Yes.
I think his fiscal connection would still be the same for two reasons. First, he's still a citizen of the state of Ohio, still subject to the laws, like all of us, that are passed by the General Assembly. And secondly, he is still receiving the benefits of the services that are being provided to his employer. He is accessing information stored on servers in those offices, relying upon the fact of those offices. And, as is shown in the complaint, still being able to go into that office when he needs to.
But you're saying, part of your argument is that he's a citizen of the state of Ohio. What if he lived across the river in Covington, Kentucky?
Well, I guess my simple answer to that question is that's not this case. But the second answer to that question is he's still receiving those same benefits, there is the same fiscal relation in
Right.
terms
So
of,
it's just the fact that his company's in Cincinnati, he dials into Cincinnati servers using Cincinnati equipment. Even if he lives in Kentucky and works from home in Kentucky, Cincinnati can still tax him for those days.
I believe the answer to that is yes. I will concede it's a more complicated case because he's not a citizen of the state of Ohio in this hypothetical.
Well, I think, but in response to the questions from both Judge Krause and Judge Winkler, as well as my earlier hypothetical, it seems like what you're saying is the distinction the city is drawing for purposes of our analysis is as long as the employer is in Cincinnati and there is some connection between the employee and the employer, it doesn't really matter where they're located. That gives Cincinnati a sufficient basis to tax him under Section 29 as the General Assembly passed it. And I just want to make sure I'm understanding your position correctly.
Well, they had to have had their principal place of work be in Cincinnati as of the outset of the pandemic.
So if they were working remotely outside of Cleveland pre-pandemic, you couldn't tax them from Cincinnati during the pandemic.
You're right. If their principal place of work was suburban Cleveland as of early 2020, before the emergency declaration, there would be no basis to say that their that any of that work. Section 29 only acts upon someone whose principal place of work was in Cincinnati as of the start of the pandemic. And the appellant's own response to our motion to dismiss attached his 2019 tax return, which showed that he worked 83% of the time in the city of Cincinnati in 2019. And in fact, his 2020 tax return, which was attached to our motion to dismiss, showed that even in 2020, he was in the city 51% of the time. So under that analysis, he did, in fact, have his principal place of business in Cincinnati. And I don't think that the appellant contended otherwise at any point here.
Mr. Anderson, you're at your time, unless the panel has any further questions. Okay. Thank you for your argument. Mr. Ault, we'll give you 3 minutes of rebuttal.
Thank you so much, Your Honor. One point of clarification at the beginning: opposing counsel in their brief and today have made arguments about connecting, how it is that Mr. Shaw connected to servers or what facilities that he availed himself of remotely. None of that information is in the record. That was added out of whole cloth. It's not clear, for instance, I don't know whether his employer maintains servers in their office or whether they use that cloud-based system, which is located outside of the city of Cincinnati. I'm not sure that it's relevant, but to the extent that that is important to this court's determination, any averment there must be viewed in the light most favorable to the non-moving party. I wanted to touch on a couple of things. Judge Bergeron, you had specifically asked a question of opposing counsel with regard to how Section 29 would deal with an individual who isn't working from their office for reasons other than the pandemic. The scenario that you mentioned where you might have been working for a law firm and doing things where you didn't have a regular schedule to be in the office. That's precisely the situation Mr. Shaw faced here. He regularly worked from outside the office, both in Blue Ash and remotely around the country. And he regularly received refunds for those days that he was not working in Cincinnati, because that's what Cincinnati is required under the statute, its own ordinance and the Constitution to do. Section 29, in fact, does seem to contemplate that individuals in that situation should not be taxed for the days that they're working outside the city, because those days would be days worked for reasons other than the state of emergency. And so in this case in particular, Mr. Shaw did receive a refund for those days that they calculated he would have been working from home anyway, under his pre-existing work conditions. They did not, the city of Cincinnati did not refund him for those days that he was working from home because of the state of emergency. As to the question of Article 18, Section 13 limitations, opposing counsel says that that particular provision states that the General Assembly has the authority to limit, but doesn't say that it doesn't have the authority to prohibit expansion. But that's not the way we read statutes or constitutions. Expressio unius is a canon of construction that we use in interpreting the Ohio Constitution, and the Ohio Supreme Court does so even in cases where it's interpreting the powers of the General Assembly. I would point this court to the attention of Board of Elections for Franklin County versus State ex rel Schneider, which applies expressio unius to the General Assembly's power under the Ohio Constitution. So the expression of the power to limit expressly disclaims the power to expand. Opposing counsel is just plainly wrong in terms of statutory interpretation.
And Mr. Alt, you are at your time now.
Thank you.
Thank you both for your argument. It's a very interesting case. We'll take the matter under submission and get out a timely written decision. And we hope you both have a great day.